Thank you very much for your invitation to give this keynote address. One of the features of globalization has been a consensus which stretches across the world that cartel behavior is something that is detrimental to open economies, and that appropriate regulation is required to ensure that cartel behavior is eradicated in such economies. And even though now there is much talk about the limits of globalization and the ways in which that trend in our international life may well be reaching its end, don't think there's any diminishment of our concern around cartels and the priority that they should enjoy in respect of the way in which competition regulation takes place. What I want to talk about in this keynote address are the following matters. I wanted first to speak a little bit about how cartel behavior comes about in economies and how very difficult it is to sometimes prize open economies that have a set of interlocking historical relationships which become the fertile soil from which cartel arrangements emerge and why they remain durable, even in the face of legislation which quite clearly prohibits them and renders them unlawful. The second thing I wanted to touch upon in this keynote address is just to reflect a little bit upon what might be called the threshold questions that often arise in jurisdictions such as this, which are seeking to enforce cartel provisions in the Competition Act, and how one negotiates these threshold questions. The third thing that I wanted to talk about concerns some of the complexities in the law around cartels. There's much comparative experience that has occurred in South Africa, in the EU, in the US, and indeed in this jurisdiction as well. There have been some cases that have sought to deal with some of the complexities that can arise. And then lastly, I wanted to talk a little bit about how one pursues cartels and how one seeks to get better enforcement and a remedial regime that is going to be effective. And I'm going to try and do all of this in, I think, my allotted 20 minutes. So let me begin at the beginning. I wanted, as I indicated, firstly to deal with why it is that cartel behavior is sometimes so ingrained in economies, even though if you would ask most people to comment on cartel behavior, they would say that it is self-evidently unlawful and is something that should not be engaged upon. So the standard features of cartel behavior, which are almost universally prohibited, are price fixing, market divisions, agreements between competitors around trading conditions, and bid rigging are the hallmarks of cartel behavior that are standardly subject to prohibition across many jurisdictions. So why is it that upon promulgation of laws that prevent this behavior and make it perfectly plain that this is amongst the most egregious infringements of law, that we find cartel behavior so rooted in so many economies? And I think there are a few observations to be made about this. The first is that in relatively small economies that have been relatively isolated from international trade and the disciplines of competition, one finds that there are a set of interlocking relationships that often arise, particularly within business relationships, that are highly durable and extraordinarily entrenched. Sometimes this is reflected in associations. Many areas of the economy are subject to associations. These associations can be benign. They can talk about matters of common interest that might actually be to the benefit of the industry or indeed even the economy as a whole. But we know also that these associations can provide the opportunities and the social fabric out of which there are agreements that take place, discussions that occur that can lead to cartel behavior. So Firstly, there are the ways in which business is organized, both within sectors and across sectors, which, as I say, sometimes is benign, but very often provide the institutional structures for cooperation that can very easily either develop into cartel behavior or simply allow for the ongoing cooperation between competitors where competition should apply. The second is that as a social formation, business, of course, operates in many social categories where there is ample opportunity for interaction, and there is simply a lack of discipline around observing what needs to be observed, which is that businesses and firms in economies are required to compete with each other, to drive each other to the brink in a competitive engagement, and not to adopt what a famous English economist once called the quiet life. It is so much easier in so many settings to simply blunt competition, reach understandings and arrangements, simply choose in a variety of ways to compete less fiercely than one should in a market, because it seems more socially acceptable. It is part of what would ordinarily be understood to be something that is socially acceptable, even if it is not legally permissible. And out of this social engagement, one often finds that cartel behavior arises. The third is simply that there are historical understandings and arrangements which have simply been inherited in the economy and are not even critically reflected upon by many businesses when the law changes. And they just carry on because nobody has done the kind of audit that warrants a reassessment of historical practice. And so it is really incumbent not just upon regulators who have convened this conference, but also upon businesses to critically look at themselves and the way in which they interact with their competitors through association, through social relationships, in terms of the business practices that they conduct, to determine whether what they are doing really is within the scheme of the law. Because our experience in other jurisdictions, and certainly in the evolution of South African competition law, is that cartel behavior has remained extraordinarily durable when one would imagine that it would have long since become an exception. I don't say it's the rule, but certainly it is much more prevalent than one would have thought likely after such a long period of competition enforcement. And it requires critical, careful appraisal by all who must live within the bounds of the law. It's not just a question, of course, of adhering to legality, important as that is, but it's important to recognize just how much is lost through cartel behavior, however convenient and comfortable it sometimes seems, and how valuable it is to an economy to adhere to competitive norms as an open economy that becomes competitive and yields to all in the economy the opportunities that are warranted in such an economy, and which have often been historically denied through the very kinds of practices that cartel behavior demonstrates in many economies, this one included. Let me move then to the second topic, which concerns what might be called the threshold questions. In almost all enforcement regimes, such as the Namibian Competition Act and other pieces of legislation of this kind in other regimes, one finds that there are a series of threshold questions that are often raised for the purposes of trying to enforce cartel, anti-cartel provisions in legislation. And this jurisdiction has encountered exactly this phenomenon most recently in a case concerning the medical schemes, where the first question that arises is whether the Competition Act applies at all. And this usually raises a cluster of questions. And let me just again illustrate some of these difficulties because they are important ones and they are threshold issues for the purposes of the effective implementation of the Act. The first concerns the question as to how the Competition Act lives alongside other schemes of regulation. So in the medical schemes case that was decided in the High Court in Namibia, the question was, how does the Competition Act and its prohibitions live alongside the Medical Schemes Act, which appeared to permit of the development of common tariffs for medical schemes? And that is a typical instance of how do regulatory regimes live alongside one another? Is there a priority of one regime over another? And how is this cohabitation to take place? The second issue that arose and arises frequently in respect of these threshold questions is, apart from whether a piece of activity is separately regulated in another regime, the question is whether the Act applies at all to the particular kind of activity that is being engaged in. So typically under the Namibian legislation, whether this is an undertaking that is engaging in profitable activity or for gain, as the definition of undertaking is formulated in the Namibian legislation, or whether it is not an undertaking for gain at all, whether it is a different kind of commercial activity to which the Act doesn't apply. Again, demonstrated in the recent case where, again, these points were taken as to what is the correct understanding of an undertaking. Is it a form of business to which the Act applies at all, or is it a separate form of commercial endeavour? Resolved before one can get to the substantive provisions of the Act and their application. And Namibia, like other jurisdictions, is having to grapple with these questions to carefully demarcate how the Act applies and to whom. And it thus far appears from the limited jurisprudence that has been developed that the courts are taking a wide view as to what all economic activity means, what the concept of an undertaking is, and the way in which the Competition Act has a wide application, even where there are separate schemes of regulation which would seem to regulate the industry alongside the Competition Act. So thus far, the experience here, alongside the treatment that these kinds of provisions have been given in other jurisdictions, is to give the full weight of the Act in terms of its application to the Namibian economy. That these matters, of course, will take some further time to be resolved through the courts, but it certainly appears that the threshold questions are not being interpreted in such a way as to constrain the application of the Act, but rather give it an expansive and wide application. And I should say that is an important bridge to cross, because if jurisdictional limitations are used to restrict the ambit of the Act, it can reduce its efficacy, and its efficacy is important to securing the openness of the economy. Let me then come to the third topic that I wanted to touch upon, which concerns the question of complexity. There are, to use ordinary language frequently applied in this area, hard cartels. These are forms of behavior which just in and of themselves are self-evidently unlawful and stand to be condemned. So in the typical case where competitors in the market get together in the smoke-filled room, as so often referred to, and agree upon pricing or choose to divide up their customers or engage in other forms of standardization of their trading terms rather than competing in the market, one would standardly think that in that kind of conspiratorial circumstance, there is little question that this is a hardcore cartel, it stands to be condemned, and little more is to be said for it. But we know from experience that there are forms of collaboration between parties who might appear to be competitors, which do not always constitute hardcore cartels and give rise to much more complex legal relationships and economic relationships, which simply don't stand to be condemned outright. Now, in the South African law, we have taken a route which has given rise to considerable difficulty, where on the one hand we have tried to condemn the outright practices of price fixing, market sharing, and the like by way of per se prohibitions. That is, these forms of conduct are condemned without any consideration for their effects. And we have sought to differentiate those from other forms of agreements between undertakings where we will apply a consideration as to what effects those arrangements give rise to as to whether they have a significant lessening of competition. What has happened in the South African experience is that we have struggled with the problem that there appear to be certain arrangements which might seem on their face to be subject to outright prohibition, per se unlawful, which we really do think on reflection do not warrant that kind of treatment. And there have been numbers of cases which have sought to grapple with these problems. So, for example, there are certain kinds of joint ventures which, though they are brought together by competitors, may actually be a form of economic activity that can be pro-competitive or at least neutral in its implications. We've had cases which concern what is called dual distribution, where a firm has certain distributors of its own, but also contracts with others independently to distribute. And we have struggled to understand whether those relationships are anti-competitive as between competitors, or whether they are just another form of distribution that doesn't stand to give rise to outright condemnation. This is a perennial problem when it comes to cartel behavior. We are always seeking to differentiate what seems to be harmful behavior that stands to be condemned outright and other forms of collaboration which do not warrant this kind of treatment. To give you but one further example, franchise arrangements, which are often a very important mechanism for developing small and medium-sized businesses in economies, all work on the basis of some territorial exclusivity that is given to franchisees, various forms of standardization as to terms and conditions, and indeed standardization of pricing arrangements. Now, the question as to whether franchisees can be standardly understood to be potential competitors in any meaningful sense is the kind of problem that arises if one has a legal regime which is too quick to condemn all forms of collaboration, even though they might amount to economic relationships that are not of themselves harmful and indeed may form part of a scheme of activity that can be highly pro-competitive and efficiency enhancing within an economy. I rather think that the Namibian legislation has taken a very much more sensible course than has South Africa, where instead of seeking through a legal classification to distinguish between those practices that are per se unlawful and those that are not, it has sought to look at various kinds of agreements, arrangements, and understandings and try to understand whether by reference to their object or effect, they give rise to a significant lessening of competition. I think that regime gives rise to considerably more flexibility than has occurred in at least the South African experience, but the flexibility of the legal regime doesn't avoid the complexity of having to discern carefully which kinds of relationships should be condemned outright because there is nothing more to be said for them. They are simply a blatant effort by competitors to avoid competition, fix prices, divide markets and the like, and thereby increase prices or restrict output or both, and whether one is dealing with a more nuanced set of relationships which could be anti-competitive, but where one has to be much more cautious as to what their effects are before one condemns those practices, because there is a risk if one does not properly apply this regime, one will condemn too much. In other words, that the regulation will be overextensive. But one has also, of course, to worry about the opposite risk, which is that the condemnation is under-inclusive. In other words, you are insufficiently getting to all the practices that are harmful in your economy. And steering this path between over-regulation and under-regulation is a critical part of the role that the Commission plays and is a critical part of the analysis which lawyers and economists who look at these problems must bring to bear when they think about whether a practice between competitors or potential competitors should be condemned or should not. That's the issue around complexity. Let me come finally, if I'm still within the bounds of my time, I hope, to some of the dynamics around cartels, how best to discern whether there is cartel behavior, and how best to ensure that one has an effective regime. Now, here too, there's no magic recipe, but there are a number of useful pointers that one can look to. Plainly, when there are a limited number of competitors in a market, and where it is the case that the products that are sold are relatively homogeneous, and if one can discern in such markets that there are pricing practices or other forms of restraint which seem unlikely to be the case if there were competition to prevail in those markets, those are the kinds of circumstances which, at a first cut, one should look at carefully to see whether what is creating this pricing uniformity is not the sharpest kind of competition, but is in fact various forms of arrangement, agreement, or understanding. That's the sort of soil from which one would want to analyze whether there is cartel behavior that is occurring. But there's another thing about cartels which is notoriously remarked upon, and it's this, that cartel behavior can often be extraordinarily unstable. And it's unstable for the following reason, which is that the best possible circumstance for a cartel participant is to have everybody else adhere to the cartel, but to engage in price undercutting yourself in secret, because by so doing, you not only force everybody else to a price, but you secure a market share that you would otherwise not have to endure if you adhere to the terms of the cartel. So cartels can be unstable, and because they are unstable, that we should look to regimes which provide incentives to cartel members to come forward and seek leniency for their behavior. There is no force that has been as disruptive of cartels and as good for the economy as the inducements given to cartel members to break up these cartels. In many jurisdictions, including South Africa, there has been an extraordinarily successful leniency policy, which allows to those who come forward to confess the cartel behavior that they will avoid administrative penalty. And it creates what is sometimes referred to as the prisoner's dilemma, which is that the incentive to come forward and avoid all penalty provides an extraordinarily high incentive to break up cartels, and it has been very effective in South Africa. I know there are discussions in Namibia to bring such a regime into place. It should be done as quickly as possible because it has an enormously beneficial impact on breaking up cartels and causing some of the cozy arrangements which I reflected upon at the beginning of my remarks to start coming apart at the seams. The other point is this, which is that cartel behavior is highly responsive to the fact that when it becomes clear that there are very substantial penalties that flow from cartel participation in cartels, the message does get across. Not always as quickly as one would hope, but as has often been remarked upon, the penalty must be so great that nobody thinks that the calculation of making profits through cartels will pay off, because it will always be greater than the penalty that is likely to result upon detection. Those kinds of swinging penalties, which are not simply there out of the sheer lust for retribution, but simply to send the deterring message that is required, provides a very wholesome corrective to these kinds of practices. In South Africa, some of these penalties have gone into the hundreds of millions, and indeed I think more recently under a settlement, to well over R1 billion. And that really does send a cold, hard message that whilst cartels sometimes have been tolerated and even enjoyed by the business community over time, they simply cannot be tolerated, and the consequences of detection are very, very great. There is so much to be said by getting rid of these historical practices, leaving these past understandings behind. And there is so much to be gained both for the economy and for the way of doing business in an open economy, that one does, and I think this is the general message that the Commission is trying to send through this open conference, that it does require reappraisal. One must be very thoughtful about the way one has done one's business in the past, but there are great gains to be made by leaving this past behind and engaging in competition as the Act so wholesomely encourages. I thank you for your attention.